Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Naomi Comfort, and Naomi is an attorney with the Silicon Valley Elder Law Group, PC. And this is a new name for her company, but anyway, and they're relocating to San Jose. Today is about the 23rd of August, to give you folks a reference anyway. And anyway, Naomi's been a guest on my show before, and so it's always a delight for me to have you as a guest, Naomi, so thank you for coming. And anyway, so today we decided to talk about something a little different. We're going to talk about durable powers of attorney and how they're utilized in estate planning to protect your finances. And I guess almost as much important as, just if somebody is disabled, how to step in, how somebody can step in.
Exactly.
Okay. Anyway, as I get started with this, I'll just alert our guests again, or not our guests, but our viewers, that this is a starting point, that actually this is rather an involved subject. It doesn't seem like it should be for a little piece of paper, but anyway, it is. And so it's intended to be, our discussion is intended to be just a starting point for a continuing conversation with your own attorney. With that, let's get started, Naomi.
All right, let's do that.
All right, let's do it. Okay.
I'm just going to interrupt immediately, like I always do. It is a simple-looking document, that power of attorney for finances, and people think, well, can't I just fill it out myself?
Yeah.
And people do, and they mess them up because they don't understand the terms. So when you go to see an attorney to prepare one of these documents for you, you're paying for their brains, for their history and their knowledge of how each of those terms are used and why they're used. You're paying for the counseling. So that's why it looks simple, but there are lots of complex issues that are being addressed in the documents.
Right. And if you just screw some little thing up, then all of a sudden you've got an invalid document and it's not going to accomplish what you want it to.
And it's going to cost you a lot of money and a lot of pain.
Yeah,
so,
inconvenience, yeah.
Yeah.
Right. Okay. Well, let's take it from the top. What is a durable power of attorney?
A durable power of attorney, first of all, let's say what a power of attorney is. A power of attorney is a document whereby you, the principal, nominate another person, the agent, who's going to act on your behalf with respect to financial matters. Whatever you specify in the document are the financial matters that you're giving them authority to act on. A durable power of attorney for finances is special because if you become incapacitated, it remains in force and effect. If it's not a durable power of attorney and you become incapacitated, the agent automatically has no authority under the document. So what we're talking about today, what we do as part of the estate planning and planning for incapacity, is we create these documents that are durable powers of attorney for finances, and they actually have special language that has to be in there. It specifically says that this is a durable power of attorney and it shall continue in full force and effect even upon my incapacity.
Right. Now that's incapacity, but now when the principal passes away, then that's the end, right?
That is the end, exactly. So the agent has authority from the moment they're given authority. It could be immediately upon execution of the document, or it could be a springing power of attorney, meaning that the agent doesn't have any authority to step in unless and until the principal is disabled. And then the agent's authority will continue, unless it's revoked, until the principal passes away. The moment the principal passes away, the agent has no authority to act under that document.
Right.
Which can cause problems when people don't realize it, and then they commit fraud, and we have to straighten things out. But that is a very important distinction.
So it can be sort of accidental, but the idea is to be aware that when the person passes away, now the executor, the trustee, is going to be stepping in as far as having the authority.
Exactly.
Yeah.
Exactly. You can no longer sign on behalf of the principal because the principal is not there.
Yeah. Okay. All right. Well, these days, revocable living trusts have become very popular. So, if you have one of these revocable trusts, does that mean that you don't need a durable power of attorney or a power of attorney?
Actually, you need both documents. The living trust is going to be a vehicle that's used to hold title to your major assets during your lifetime. It provides for disposition after you pass away, and it also provides for a successor trustee who would step in and manage those assets on your incapacity. So it does seem like it's doing the same thing. It's got a mechanism to handle finances on incapacity. But the successor trustee only has authority to deal with assets that are inside the trust. So if your house is titled in your name as trustee, then the successor trustee can manage the house. Some things can't be put in the trust during your lifetime, and these can be big things. Your IRA, your 401k, under the tax laws, those stay in your individual names during your lifetime. So if you're incapacitated, your trustee can't do anything to manage those assets. You need an agent under a power of attorney for finances who can step in to manage those IRAs and the investments and the required minimum distributions and that type of thing. The other situations that the agent will handle as opposed to the trustee handling them, dealing with the IRS, filing your tax returns, dealing with Social Security, paying your utility bills, those are always going to come in your individual name. And one of the biggest issues is dealing with medical billing, because a lot of times when somebody's incapacitated, there are a lot of medical issues going on and billing back and forth, and those don't come to addressed to the trustee of the trust, they come addressed to the principal individually, and so it's the agent that steps in. It's a very, very important document, and many times if somebody has become incapacitated and they don't have that document in place, they have the trust, but they don't have the power of attorney for finances, we unfortunately will have to go in and initiate conservatorship proceedings, which are extremely expensive and disruptive to the family or the individuals, but that's the only way that we can get access to and manage and control and protect those other financial pieces.
Okay. Well, now let's say I'm married. Can't my spouse just step in and take care of this stuff?
You know, that would be so logical, and I wish it was so easy, but our legislature has not made it so easy. So married couples have a fiduciary obligation with respect to how they treat each other and their finances, but that does not give your spouse the authority to go into your accounts that are only in your name if you are incapacitated. You have to actually specifically authorize your spouse to get into those accounts and deal with those items. So the fact that you're married does not negate the need for having this power of attorney for finances. Now, most of my married couples name their spouse as the agent, because of course that's who they typically would want to step in to handle these things. I mean, they already know what the finances are, they know what needs to be done, and their interests are aligned. But the spouse's authority to act is because of that written document.
Okay. Well, how about just adding the spouse or one of your children to your account, giving them a signature authority on the account?
You're trying to keep business from me, aren't you? You're trying to find ways around how can people not have to do these powers of attorney.
Well, you know, so there's a lot of people that really don't want to go to attorneys, and so they're trying to think of these things about, you know.
Absolutely, and I totally understand. So the reason that people do that, people do add somebody else's name. They add the spouse to the account. They add a child to the account. I do not recommend that as a first option for most people. And the reason is this. Under California law, when you add a joint owner to that account, either owner is entitled to withdraw the entire balance of the account. So if you have a $50,000 account that's your separate property, and you name your daughter as a on the account because you want to make sure somebody can access it if you're incapacitated. Your daughter could go in the next day. She could withdraw all $50,000 of it, and it's hers. And she has not done anything illegal. Mm-hmm. She's done something immoral, and you'll probably now disinherit her, but it's completely legal. More concerning is her creditors. You wouldn't have put her on the account if you didn't trust her. Mm-hmm. So you're probably thinking, you know, my daughter would never do that, so I can put my daughter on the account. Well, your daughter may have creditors, unknown creditors. You know, she could lose her home in foreclosure. I mean, people are having all sorts of credit problems at this point because of the economy. But ex-spouses get in a car accident, medical bills, anything could come up. So, you know, it's not the safest option. It is the least expensive option. If you really have no way to pay for an attorney to help you with this, mm-hmm. you could name somebody as a co-owner. But there is actually one other solution that's better. If you absolutely can't handle talking to an attorney about a power of attorney for finances, and you need to have a second person named on the account, there is a special kind of power of attorney for finances that the bank itself can authorize. It's specific to that account, and you go into the bank, you fill out the form at the bank naming the agent who would step in on incapacity, so you don't have the ownership issues, you don't have to pay an attorney, mm-hmm. but it only applies to that particular account. So if you change account numbers or move to another bank, it automatically goes away and you lose that piece of protection. So there are alternatives to having to deal with an attorney.
Yeah.
But your safest bet is to work with the attorney so you have a consolidated plan so that your trust and power of attorney, or your will and your advanced healthcare directives, so that all these documents work together and really function in a way that will mitigate the pain and expense associated with incapacity and death.
Right. Okay. So I think what the key is that, again, it's the difference between giving them some signature authority via a document, like you said, it's the power of attorney form that the bank provides. Correct. Instead of making them a co-owner on the account or a joint owner.
Exactly.
And in the past, I've seen a lot of families where it seems like, you know, you got mom, dad, all the kids, you know.
Yes, 7 people named as owners of the account, just in case.
And actually, that does have a tax consequence when you do that. Theoretically, you've actually made a gift. And if IRS looks at it, certainly they'll say that you've made a gift. So
my research actually was that the gift happens when the person takes the money or when one person dies, not when you just put the names on the account, because anybody can still take the money out.
Well,
have you read it differently?
Yeah, I think so.
Okay.
On the other hand, the person can take all of it out, and when they do, then yes, certainly, because it's not just a share then, they've just taken the whole thing. And so anyway, but there's always this issue where they say, oh, well, it's for convenience, and so we sort of look the other way.
Right.
And but there's better ways to deal with convenience, and that is to, again, you don't give them title on the account, you can give them some signature authority. Right. And I do that, for example, from my business. So like when I'm out of town, my daughter can write checks, who's my office manager, you know, so that I don't have things like, you know, getting late notices for my credit cards and things like that.
Right. So with the document that you can get at